When you're up against a hostile room of people who don't want to be there, you need real strategies that get results. Welcome to From Hostage to Hero, the show that gives you practical advice you can use right now in the courtroom, boardroom, or classroom. Learn how to move your unwilling audience to one that is invested in what you're saying, eager to participate, and engaged in the process. Learn from the attorney whisperer herself, your host, Sari Delamotte.
Well, welcome everyone to another episode of From Hostage to Hero. Sari Delamotte here with some very, very special guests. We have Nick Loisi and Shauna Wrights, along with Coach Jody, because she's here because I want her on all the podcasts. And no, she's not in my basement this time. She's actually back home. I've allowed her to see her family for a few days before taking her captive again. But we are here to talk about the amazing verdict that these two just received a few months ago and hear all about it. So welcome, Nick, Shauna, and Jody to the podcast.
Hi, everybody. Thanks for having us.
Yeah, thanks for having us.
Absolutely.
Awesome.
So let's start by talking about how you came into my world, into the H2H world. What brought you to H2H?
Well, I'll start. It was through our co-counsel on another case, who happens to be one of your longtime followers, Tim Whiting. So we were co-counsel with him on a case, and we had this big medical malpractice case, and we were really struggling with it. And we had a conversation with Tim, and he said, "I know what you have to do. You have to get together with Sari. That's just the bottom line." He's like, that is what you need. And so that's how we came to you.
That's exactly right. And we really respect him. He's an excellent lawyer here in Chicago, does trucking litigation. And I think he said something to the effect of, "You were a genius." Sorry.
Yes, he did.
Oh, wow.
So,
Tim, love you. If you're listening,
true.
and I know you will be, know that the email came in from Tim saying, "I know you don't work with people one-on-one anymore unless they're in your crew, but you have to take a call at least with these people. They're amazing." And so we had that phone call, and I brought Jody in to help because I've been so busy this year, and it ended up being an amazing, amazing thing. Before we get into that, tell us a little bit. You mentioned you're in Chicago. I should have said that first, but you're based there in Chicago. What have you been doing up until this point? What kind of law are you practicing? Have you been to trial a lot? Let our listeners know a little bit about your background.
Yeah, so we have been to trial a lot. We've tried a lot of cases. It's actually interesting because Shauna and I met at a defense firm early in our career. She was actually my boss, believe it or not. And
she still is. I mean, come on, let's just be honest.
My task was to follow her around and learn and watch her try cases. And I did that. And then obviously we became, just more than just co-workers, and started dating. And fortunately, the firm that we were at, that was not frowned upon. So we were dating, and then eventually it got to the point where I just thought that we should probably go somewhere else. One of us should go somewhere else. And so I did, and I went and I started doing, and that was a defense firm, by the way. Yep. And I started doing plaintiff's work at a really good Chicago firm, and I learned how to do medical malpractice and just the larger cases. And then I received an opportunity to join with another attorney who was well-established, an older person that had a really good firm, and he'd gone through Jerry Spence's class, and so we became partners. Meanwhile, Shauna was still at the old firm, and so we got some good verdicts with that other firm, and then the individual was basically talking about retiring at some point, and we just thought that it was a natural point in time to separate. And so I went on my own and just started doing some of the cases that I learned to do when I left the defense firm, and then eventually Shauna joined me. So, and that's what we've been doing. So we do a lot of medical malpractice and just larger
plaintiff
cases.
Work.
Plaintiff.
100%.
100% plaintiff.
100%. And the majority of our cases are medical malpractice and just larger catastrophic cases. We try to stay away from the smaller cases. And Tim was actually instrumental with that as well, because I know you coached him to work on just what he knows best. And so that's what we're trying to do. We're actually trying to get our caseload down to where we could just focus on just cases like the ones we just tried. And we've tried a lot of
Wow.
medical malpractice cases, but this was the largest in our office, at least. So
Well, Jody and I have done several podcasts in the last couple of months where we've talked about really the winning formula. And it's so great to have you here because you pretty much did exactly and proved, well, you proved us right. So that's why we love you, actually.
yeah,
But which is a couple things, right? So there was the collaboration part. We just think is so huge because when you get so laser focused on your case and you don't have the outside point of views, it's difficult to do what you were able to do here. But also you put in the time, and that's what I keep hearing when we hear about reducing caseloads and niching down and really doing what you do well and taking on the bigger catastrophic cases. It allows you to put in the type of time that is required of these cases. And so I see so many trial attorneys beating themselves up because they aren't getting the results that they want. And I say, well, how many cases do you have? 200. Well, okay, there's your problem, right? But it does take a lot of, risk to be like, okay, we're only going to have a certain amount of these cases, and so they better pay off, right? So there's that part as well. How long have you guys been in your own firm now?
we actually split off. I've been on my own since around 97, I believe it was. And then Shauna eventually, like after she left the defense firm, she was a partner at the defense firm. She left and raised the kids for a while, and the two kids, Kayla and Nick, and grown up now. But and so she just decided she used to do a lot of medical reviews. And then eventually we've tried cases together. And so I'd say since then.
Yeah. No, we've been at this for a long time,
Yeah.
So, we've been practicing a long time. We did have, a couple of cases that didn't turn out the way that we would have liked. But one of the things that we really focused on within the past couple of years was just trying to keep learning and try to make ourselves better and do a better job for the clients. And so we've been, collaborating, to use your term, which is nice. And we've really liked it. And Tim, the case that we're working on with him has just been a wonderful experience. And then this time working with Jody on this case was just amazing. That was something that we were really missing, was that collaboration, and that was essential.
Right.
Well, and that's why I want to go to Jody now to get her voice in the room. So when y'all came to me, I was like, hey, if you guys want to buy out a trial lab, that's how I can work with you. But I'd like, since you're new to my method, for you to work with an actual consultant before you get here. And so we brought Jody in on the scene, who is a med-mal nursing home expert. And so she was just perfect for this. And Jody, what did you think when you first met the Luizzi's? Well, they aren't both Luizzi's, but that's why we call them the Luizzi's.
She came and met us in Chicago.
Yeah.
She
Yeah.
did.
Yeah. Well, you keep sort of burying the lead, right? That these two are married. We talked about all their partnership, right? And then the kids, and then she raised the kid. It's like, okay, these two got married somewhere in that timeline,
Yes,
right?
yes, they did. Mhm.
So that was super fun.
Almost 30 years.
Yeah. That's
Yay.
right. Congratulations.
Yeah.
So it's always interesting, right? When folks reach out to Sari, right, of Sari Delamont fame and Hostage to Hero, for her to say, okay, well, you can work with Jody for a period of time, and then you can come to a trial lab to work with me. And there's always this sort of initial, like, who's that? So I do remember our first Zoom, where Nick and Shauna were sort of like, well, if I have to go through Jody to get to Sari, so be it. So I
And
had to work
then they were like, sorry,
magic a
who?
little bit.
After 6 months with you.
Yeah. So I had to work my magic a little bit, right? Which was, I did go to Chicago. We did a 2-day workshop, and I do remember.
Jody, it was
What
4
was
days.
it? 3 days? Was it 4 days?
4
Okay.
days.
No, it was only 2 days. It was only 2 days. Maybe
It felt like
4
4.
days.
That was 4.
Yeah. Time flies when we're having fun. But I think the biggest thing that stood out to me was, you guys were really looking for clarity, right? You guys were
Mm,
like,
mhm.
we've worked on this case. It's very important to us. That was really clear to me from the beginning, by the way, like how much you cared about the case and how devoted you were to trying to get it right. If I'm putting right in air quotes, that there's a right way to do things, but to really do right by your client. So that there was an alignment there from day one, right? Of how committed you were and how caring you were for the case and your client. So our time together was really spent, and what I thought my role was helping you get clear on what pieces of information and what story do you need to tell to be successful, and kind of having that bird's eye view or that 10,000-foot view. And I really related to it because I litigate my own cases. And in my own cases, of course, I'm like, everything's important. I want all the information that I developed. Of course, I need 12 experts, and all 80 witnesses are going to come to trial. So I really had a lot of fun, if you will, to kind of coming in and stepping into your lives and into your cases and being able to provide that framework and architecture to get the clarity that you needed. It was really, really a joy and a pleasure to work with you.
Yeah, well,
Wow.
the case that we had, and I don't know if you want to get into it, but it was just so many people did so many things wrong at so many different times that it was like, the old George W. Bush, remember the 1,000 points of light? We had 1,000 points of light, but they were going in all different directions, and we needed to just a few
Clarity.
points, just a few points of light to focus on what's really important to present to a jury. Because if you presented every one of those points, the jury would have been, I mean, the trial took a month. So imagine what it would have been like if we didn't cut a lot of stuff out. But
Well, and I
you
think
brought
that's
that to us.
true in medical malpractice in general, right? I mean, we only win, lost my look, 27%. We have a 27% win rate with medical malpractice. And I think part of that is, yes, what we hear out in the ether, which is, well, people don't want to, hold doctors responsible and all of that kind of stuff. But I have to believe too that part of it is because people do not take the time to get as clear as you guys got and present it in such a way that was so clear that immediately the jury got it. So yes, let's get into the case. Tell us what this case was about. Give us kind of the bird's eye view, and then we'll just kind of dive into how you handled it at trial.
Yeah.
Well, yeah, I mean, it was medical malpractice, but it was a little bit complicated because we had a case against the resident physicians who were in training, and that was a big theme. It became a big theme, and the individual providers and nurses. But then we also had an institutional claim against the hospital for failing to supervise and train their employees. So that in and of itself made it more complicated and convoluted than your typical malpractice case. So do you want to?
We also had, and there was also an attending that was implicated.
Yes.
That was supposed to be supervising all of these residents. And the residents, by the way, the case was, it was literally the beginning of the residency year, the end of June. And a lot of people don't know this, that the residency programs begin at the end of June and they go through the following year. And everyone is in a new role. All the interns are coming from medical school. The first year interns become second year interns. They're in different positions, in different roles. So it's just chaos. And it's so important to make sure they have someone supervising these physicians to make sure that the patients are safe, that they are kept safe.
Well, this is what I love about this case, is because if we look at the trajectory and where we came from to where we ended up, they were two totally different things. And for our listeners, this was a case about a man who came to the hospital for some very benign reason. His
Right.
salt levels, right, were not
Right.
correct, and they were keeping him, and he couldn't sleep. He's given an Ambien. He has the adverse reaction, which is to get I wouldn't say, what would we call it?
Agitated.
Aggressive.
Yeah.
Agitated. And so then they sedated him. Of course, they over sedated him, and he ended up actually having
Cardiac
stop
arrest.
breathing, right?
Yeah.
And
Respiratory
so
arrest.
he had
Yeah.
respiratory arrest. And so when we first started, it was the whole thing we were hanging our hat on was, well, they should have sent him to the ICU. And that's, it was very medical oriented, and who did what wrong and why, But as we peel back the layers, the story that emerged actually was quite different. Jody, I want to hear your thoughts on kind of that trajectory, because I don't say that as, oh, whoa, we were totally wrong at the beginning. We always have to start somewhere. Well, maybe it's this, and then play with it, and then we get clearer and clearer and clearer and clearer, which is what was so fun about working with you two, is we had 6 months to play
Right.
with it before you brought it out here to the 2 juries that we had out here. Jody,
Yeah.
kind of
Well,
that
I
view
sort
of
of
the
picked,
clarity.
yeah, I picked up on the same energy, right? As the story that Nick and Shauna just told about the hierarchy and the chain of command and the institution. That's of course the story they told at trial, but that wasn't the story we started with. We started
That's
with
right.
this was an Ambien overdose, right? And so how do we reverse the effects of Ambien, and how do we figure out
Ativan.
what the
Ativan, yeah.
sorry,
Ativan.
sorry, an
Ativan.
I
adverse
said
reaction to the
Ambien. You're right.
Ambien. Yeah.
Mhm.
So they had Ambien to go to sleep. That made them agitated. Then they got Ativan, and then they got Ativan again, and then they got Ativan again, right? And lo and behold, he goes to sleep, right? And yay, he's no longer agitated. Well, he's not really asleep. Now he's in respiratory depression, which turns into respiratory crisis, which leads to respiratory arrest, right? So the initial sort of conversations and rounds had to do with, well, was it appropriate to give him Ambien? And then if so, was it appropriate to give him Ativan? And then if so, could you redose it? And could you redose it? And we had a lot of focus on when was it appropriate for him to move to the ICU. And so in the arc of working on the case together, we initially thought the case tipping point, if you will, something we call the case clarity or the XY filter. We initially thought that was going to be, we'll send him to the ICU. But and so those were the stories that were being told. That was sort of the evidence that was being developed and the focus of the case. But when we really started to ask the question, well, why didn't he go to the ICU? Why, if it was so clear he was having respiratory depression, why didn't he go to the ICU? And when we asked the 5 whys, well, then why? Well, because nobody actually ordered the transfer. Why? Well, because residents were calling residents on the med surge floor were calling residents on the ICU floor. Why? Well, because there was no attending, supervising the student doctors. Why? Well, because this hospital really wasn't set up to have student doctors who could succeed, because they didn't have the supervision and the policies in place. And now we were like, okay, the real filter, right, to get at the liability of the hospital and not the attendings, the poor attendings who are frantically calling each other, trying to figure out what to do with this guy, was that the system wasn't set up for these unsupervised doctors to be successful. And so the tipping point ended up being, if the jury believes that the doctors needed to be supervised to prevent mistakes from reaching the patients, then we're going to win. But if they believe, yeah, no, we just let interns and residents run the hospital unsupervised, then we probably lose. And so that arc, if you will, took 8 months and a lot of sessions and a lot of deep work to get to that piece of clarity to end up being the final story that was told at trial.
Well, and what I love about that too is that we know in med mal, when we argue medicine, we often lose, right? So if we're like, whether he should have gone to they should send him to the ICU. Well, not really. They didn't really have to. And we just get in this back and forth, right? Of what someone should or shouldn't have done. Where here it's, you should be supervising student doctors. Like, who's going to be like, yeah, no, they don't really need that. And again, it falls right into the Rick Friedman thing of if they either can't argue with it, or if they do argue with it, they look stupid. So I just love how you outline how you got there, which is asking, well, why didn't the thing happen that happened? And we don't always have a systemic failure, but we often do. And I think when we can find it, magic happens. What was that process like for you two, kind of going through that with Jody and kind of hearing the evolution of kind of where you started and where you ended up?
Well, it was absolutely amazing, because Jody is amazing. So like
Yes.
she's our favorite, and she's so positive too. So like the whole process, even though we would get overwhelmed and we were like just like amazingly fatigued, because we felt like we'd been on trial just working that intensely on the case. But it was like when we would find these nuggets, and when we found, oh my gosh, when we found our hook finally, it was like the biggest aha moment ever. And when we were struggling with whether we were going to own the fact that these residents make mistakes, these student doctors make mistakes, we're like, should we? But it felt so right. And when we owned it and we said, you know what, student doctors will make mistakes. And it's the hospital's responsibility to make sure those mistakes never reach the patient. I mean, it just felt so good,
Right.
didn't it? It
Yeah,
just
and,
really
and
did.
because you're never supposed to say it was a mistake, you know.
I know
Yeah.
that hook terrified Jody even after you left.
I had hives. I
But it-
broke
We're
but it
out
never
in
worked.
supposed to
hives.
say mistakes.
We don't say the M word in
But it
medical
was
malpractice.
plain. The jury got it. You know,
Yeah.
everyone
Yeah.
got it, and it fit this case. And
Yeah.
then in the beginning, when Jody first came out, honestly, we had probably 100 flip charts of just like
Yes.
notes and different thoughts and everything, and it was just like kind of like just
The
like
brainstorming.
yeah, just like
Mhm.
vomit on flip charts, and just all kinds of stuff, and then it just got boiled down. It got boiled down, boiled
Yeah.
down. We had sessions every month with Jody to clarify additionally as even more evidence came in, and as we worked up the case further, because a lot of the discovery wasn't finished yet when we first started with Jody. Like our experts disclosures, Jody helped us tremendously with that. We had the experts, but she was a big part on getting our disclosures down on paper and making sure that they're correct, and serve them on the other side. And then when the defense disclosures, same thing. But it was such a process, because honestly, like Shauna said in the beginning, the hardest part for us was there was so much information, and if we would have
Mhm.
presented it, I don't know, maybe we would have gotten a verdict. Maybe it wouldn't have been as good, or maybe we would not have. And when juries are confused, it's a not guilty.
But
You know,
yeah,
Right.
and I'm convinced.
Always a defense verdict when they're
Right.
confused.
Yeah, yeah. And I'm convinced that, the time we spent working on the opening, we had we had such confidence in our story and the way we were going to present it. And that was our touchstone. So we we did our opening, and then everything through trial was like, okay, let's channel Jody, and our touchstone was our opening, and everything fit back to the opening. So our story we kept ringing that bell, and we just kept coming back to the
Love
opening
it.
and our outline. And
Right.
it was like, I'm convinced that that's how we won the case.
And the opening didn't come
Yeah.
together, obviously, when Jody first came to Chicago. It came when we came to Portland, when we finished up the trial lab in Portland, and we practiced it, and it sounded good, and it felt really, really good.
Yep.
And so,
That was a magical week when you were all here. And so I wanted to talk about is, yes, you did this great work with Jody. Okay, enough about Jody. No, I'm kidding. And yes, you won your trial. However, I think one of the biggest, at least from the outside looking in, right? I think one of the biggest shifts that I saw in you both was mindset. Mindset was a huge, I remember when Jody came out to see you, and she's like, I brought the archetype cards. I was like, you did? And she's like, oh yeah, I'm bringing out, like this weird new age stuff. I'm like, how did they like it? She's like, Nick was a little, I don't know what this is about. But by the time you guys left here, you were like, oh my God, this is so huge. So talk to our listeners a little bit about how you were able to shift your mindset and use that new shifted mindset in trial, and how that did or didn't help you here.
well, you hit the nail on the head. When Jody came with those cards, I was like, huh? When are we going to talk about the case? And so it started then. But that was at the beginning. And then, but it's kind of, I don't want to say force fed, but it's part of the process all the way through, especially at trial lab. Trial lab was mindset. And it helped me tremendously during a month-long trial to be able to go back to that and say, okay, we got this. We've done this already. It's like one of the things you said all the time. Sorry, maybe you don't remember, but I remember it clearly. Muscle memory. There were times where I forgot what I was going to say, and then I'm just like kind of close my eyes and say muscle memory, and it would come back to me. So mindset was a huge part for me, and I know for Shauna, because we've talked about it. Obviously we've talked about the case a lot since the verdict, but especially living together.
Yeah.
But mindset was everything.
It was, and when we identified our saboteurs, which was like it was crazy, because they would come out at different times during the trial. and we were able to tell each other, nope, we've got this, that's your inner saboteur coming out and whatnot. And we'd always be able to anchor ourselves and recognize it. And to be able to recognize when it comes out is huge.
Right.
It is huge. And I think one of the things I said to you either in the email during trial or when you were here, maybe both, was just because you do mindset work doesn't mean that your saboteurs go away. The fact that you're doing something super risky means they will be there, right, in your face. But if you can recognize it as a saboteur, it's trying to help you, it's trying to tell you, don't do this risky thing. And you can have it be calmed down and go, I got this. Don't worry. We're going to survive. That in itself, like you said, the recognizing is so huge in terms of the mindset piece. Jody.
Well, I also wanted to piggyback on that and maybe ask Nick and Shauna to share a little bit about their allies, right? So we talk about saboteurs and allies. So saboteurs is sort of the negative talk, the limiting beliefs, the, oh my gosh, stop doing this or it's too risky. But we were able to help you get in touch with some allies, which is the more positive attributes, right? And they showed up in trial. So I would love for you to share with our listeners about that.
Shauna's ally is better than mine, so I'm going to let her start.
No, I love both of yours.
Well, my ally is John Wooden, the coach, and it was just such an aha moment for me because I've always admired him. My father was a coach. He used to quote him. He has assigned, he had assigned a pyramid of John Wooden's success, and it was just one of those things. I'd never really thought about bringing that positive aspect, and where it's part of what you preach, Sari, is that it's not outcome determinative. That is not how you judge yourself, which is what John Wooden always said. You can have games where you may have scored more points than the other team and lost. And likewise, you may have games where you did not score as many and you've won. And so when I realized that and started applying those principles that I preached to my kids during all their athletics and all along, and I had heard my whole life, I for some reason had never brought it into the trial.
Yeah.
And so to do that was amazing.
And your phrase during trial was
let's fucking go.
Let's fucking
Yes.
go. I love it.
But my mom might listen to this, so LFG, Mom.
That was me, Mom. I said the F word, not Shauna.
LFG. That was actually on our shower window. LFG every morning.
I love it.
Yep.
I love it.
And then
Yeah. And so Nick, yours?
My ally was kitchen table Nick, spaghetti Nick, and that came about at dinner one night at Sari's house, and it was a wonderful time, and we were all talking, and I guess I did a lot of talking. I don't know, but it came about
because you're Italian. You talk a lot.
We like this Nick, and this should be the Nick that should be at trial. And so that was kind of my ally the entire time. And I've always been I always felt that like direct examination has been one of my strong points, as well as cross-examination, because I like talking to people, and I'm not afraid to ask a why question of a defense expert if I think I know where to take them. And the same thing with direct examinations. Like our direct examination of our client was kitchen table Nick that appeared out of nowhere. I mean, not out of nowhere, but he appeared, and it was, I guess I could tell you, the jury in our case, we could never figure out what our jury was. We had them for a month. We don't know if we had a group or not. They weren't interacting. They weren't. It's not what you, Sari, would consider a group. But the one time that they were in unison, focused, leaning in, listening, was during the direct examination of our clients. The two times, Bob and our client, and of them, and that was the one time. Also, the opening. I think the opening they were engaged as well. But I really think that was the big part of it. And it was, I always kept thinking, just kitchen table Nick. That's all. Just don't overplay it. Just talk to him. And that's all.
We spend a whole day on mindset out of the 5 days that you guys come out. We spend a lot of time on mindset, and people at first are like, well, are we just going to talk about the trial or the case? And it's so important once you've had that training to realize how much it helps you in trial. I want to talk about opening for a few reasons. One is there was something that you told Jody that you would never ever do when you first met her that we ended up loving. And so it's another way that Sari is right about things, but it had to do with flip charts, right?
That was me. I
Yeah.
said, I'm
So
not,
what,
I'm
Jody,
not-
Jody, what did he say when you first met?
I will never use a flip chart in the courtroom.
Yep.
I'm not
I was there. I vouched
writing
for it.
things down. I have terrible writing. I'm not writing things down in front of the jury. And P.S. I can't turn my back on the jury. It was
Yes.
no, no, and no.
Yeah.
Yep.
And
That's
it was so
true.
funny at the end of our trial lab week, you were like, oh my God, I love the flip charts. It's the best thing ever. And so tell me a little bit about how an H2H opening is different than maybe openings you've done before.
For me, I thought the organization, the structure of it was everything. We had a courtroom full of people in the opening statement, as usually happens in some cases, but we had a courtroom full of people, some friends, some people that a friend of ours put out on our Illinois Trial Lawyers Association website that Shauna and I were going to be doing our openings on this date, and people showed up. So it was like it was a decent sized courtroom, and it was filled with people. And after the verdict came back, so many people told us that the opening was spot on. I mean, not just lay people, because we had a nurse in there that was a consultant of ours on other cases. And she said that you had the medicine, you had the structure, you had a message that was coherent, and the jury, we thought we wanted that opening. We really did.
Absolutely. And we thought when we first heard you say that we had to keep it down to like 30 minutes, we're like, there's no way. Thought there's absolutely no way. And yet we got everything in. And then it was so great because the way you undermine the defenses before they get up there, it's like, it just made the other attorneys, who were great attorneys, actually defense attorneys, but we had already basically confronted what they were going to say. And it was amazing.
Yeah.
Did you get to use some snark during that time?
Oh yes. Yes.
So ask them about splitting it up, because that was really interesting, and the difference between trial live.
I was going to say, so when you came out, the question was, how are we going to split this up? And so what we ended up doing here was having you kind of go in and out during different times in the 9-part template. What did you end up doing when you were actually at trial?
So the way we did it in for opening was that Shauna did you
started out.
I started out.
He had to do some of the teaching, and he did the defendant's story, and then I took over and did the plaintiff's story, and then did the ask, which was like, I hadn't practiced that. I had not practiced that.
Yeah.
And so
so we broke it up into 2 parts.
I would say, how was that switching from what you had practiced?
It was a little disconcerting for me, because we had not practiced switching. We had the 2 days that we were on our feet doing the openings in front of the mock jury. We kept going in and out, so we had pieces, and I kind of knew my pieces, kind of almost like an actor knows, like, this is, you come in, you say good morning, and then you get out. And so it was a little bit different. So then I had Shauna actually helped me with that a lot for the organization of it, the teaching part. Yeah. So, but and then she did the,
I love that. Now,
in
previous openings, were they longer than 30 minutes? Did you use notes?
Yes.
Was it memorized? Like, how did you work on it before?
It was interesting, because like the judge asked us, how long do you need for opening? 44 minutes. And she goes, huh? I said 44 minutes. We've timed it and we knew it. I've never done that before.
I love it.
So we knew exactly what it was going to be and how long it should have been. And it really worked very nice. The defense attorneys, they were against it. They didn't want us to do it.
They objected to us even splitting.
Oh, that you going back and forth?
Yeah. No, it wasn't going back and forth. It was just that I
mean, just sharing it.
I started and Shauna finished the opening, and then closing, Shauna started it and I finished. So they just hadn't seen it before. We had done it in another case in a different county years ago,
Yeah.
and it worked really well. I mean, we both bring different aspects to the case. I always feel like,
That's what we saw. Absolutely. You both
yeah.
had different
So
strengths
Shauna's a
and
natural
things.
teacher. I'm kind of like the one that I will argue with you to the end of the day. But Shauna will be over there and say, let's be reasonable. Let's talk about this, ladies and gentlemen. And so she just, and you put a pen in her hand or a marker in her hand and a flip chart, and she just goes to work. So it worked really well for both of us. It really did. And I think it worked well for the jury too. And
What
and
was
as
it
we
like?
saw, in the trial lab when we did the mock juries, I think they liked it too. The contrast between going
Absolutely.
in and out, not as much, but you know, just the different voices.
Absolutely. It keeps engagement. And so I think
Right.
that's great. What was it like? Because I want to be really clear that you didn't have anything memorized, right? We didn't ever write anything down on a piece of paper that had, lots of words on it that you memorized. We literally just muscle memoried this from the very beginning. I was like, just stand up and let's try that hook. Ooh, let's change this word. Let's try that again. And then we just were like, teach me. And
Yeah.
we just, every time you guys did it, it was a little bit different, a little word here. And that's what I kept saying to you. And I think that's what you're referring to, Nick, is it's going to come out totally different every time you do it. And that's okay.
Yep.
You know your case, So how was that actually in trial? Just, you're up there and you're just going for it.
Well, that was great. It was a living, breathing thing, the opening, which is great.
Yes.
But that's how we approached everything. And you also told us, which was one thing that we kept reminding each other, nothing was going to be perfect, and it's okay.
Nope.
And you got to expect it. You got to expect things are going to happen that you're not planned for and everything, and it's going to be okay. And that's, we had to keep reminding each other that. And so it was really good to like not get too vetted to it has to be this way, we have to say it this way, you adjust. And so that was good, and we kept reminding each other. I felt it was very effective.
I thought that guidance was really important, especially for me, that you're not going to be perfect. Let that go. And because motions in limine, we didn't get a lot of our motions granted. They hit us with over 100 motions in limine that we had to respond to, and we lost some that we thought we should have won that were really solid. And I just kept telling myself, that's okay. That's okay. We don't need it.
Yep.
It's not going to be perfect. We're not going to win everything. Just go on to the next thing. And the same thing with opening. Opening, I had notes. I had probably about 10 pages of notes. I don't even think I looked at them.
No, you didn't.
Once. So we did it so many times, and we knew the case, and it just comes natural. And if I forgot something, okay, it'll come out somewhere else.
That's right. That's right.
And so I guess I forgave myself if I forgot something, but
Yeah.
we were thinking about it, and we probably, what did we say? About 85% of what we wanted to do, we did in this case. And the other 15% didn't go our way, or we didn't do, and it's okay. And we still won the case.
Well, it obviously was okay because there was a very good verdict that we have not yet revealed on this podcast. So you were offered a high-low.
We were, but it was a process. It was, I don't understand, like sometimes the other side, I just don't. I always thought this case should settle for a long period of time. We struggled with the value of it. As you know, before we even came to you, we did the big data studies. We did 2 of them because the first one we didn't ask for enough, and so we thought that it was thought that we should do a second one, and we did it. And we asked for, even the trial, we asked for a sum that was that we had to get used to it. Okay. And then, so we told the jury in opening what we were going to ask for. And we could tell you, I mean, with the verdict, but the problem was that our client did much, 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 much better on the stand than we anticipated. And so when we told the jury, we're going to ask you for this much in opening, and then he did remarkably better.
It was a good day for him.
It was a really good day for him. And then we struggled at closing, and we thought, should we still ask for that much? And we told the jury we were going to, so we kind of stuck to our guns, and we just said, you know what? It's still that the case is still valued that much. We've done the focus groups on it, and so we stuck to it.
But yeah, but I was going to say when you asked us, yeah, there was a high low. Well, there was also a very
I was
scary
just going to
moment.
bring that.
Yeah.
There was an offer on the table.
There was an offer. They had offered a substantial amount of money when they got into 8 figures, and they offered us $10 million. And Nick and I looked at each other. And, well, yeah, indicated very strongly, and the judge is telling us we should take it. And plenty of other people were telling us that's a lot of money, and we looked at each other, we're like, we've never gotten a $10 million offer that, and then we've never turned it down. Which our client was the good thing was we were on the same page with our client.
Right.
Well, I have to say that was probably Jody's most proud moment, because Jody was like, oh my God, they had an offer of 10 million and they didn't take it. Like, look at those mindset motherfuckers. Sorry, Mom. But I mean, anyone in your position would have such a moment of, what am I doing? 10 million. So what made you say, nope, we're continuing? Outside of your client, I know your client supported you, but in yourselves, what made you decide that's not enough?
We thought we did the work, and we thought that there was no way a jury was going to give us less than that. I really did not think that was going to be a possibility. All the work that we did told us that, first of all, when that offer was indicated, or they were going to pull it, actually, we didn't even tell you that part. They were going to. They pulled it. They told us, you have until Sunday night to make a decision on this, and it's gone at 5 p.m. on Sunday. It's gone. This is the judge telling us on Friday before we had to make a decision, and she said, I strongly advise you to take this. This is a lot of money. It's life-changing money for your client. And we didn't understand where it was coming from and why the threat to take the money off the table. One of the things that Shauna and I always kept going back to is, okay, everything's gone in the way we wanted it to. Everything has gone our way for the most part. And they've threatened appeal. And I said, if anyone has appeals, it's us. It's not them, it's us. I said, what has changed in this case to make them want to withdraw the offer? And nothing had changed. And we could not pinpoint anything other than trying to intimidate us and force us.
That's exactly what it was.
Force our client into taking money that wasn't, in our opinion, fair, or his opinion, fair. So we just did not feel that, okay, this is not warranted. But it's not like we put on a witness and that witness was terrible, and all of a sudden you've got this ultimatum and you got to make a decision. Everything had been going really well for us. All our witnesses were spot on, and they were likable and good witnesses and rational. And the jury, you could see eating them up. So I didn't understand it. So that made it easier. But again, Monday came, there was no offer on the table, and we had to go through the entire trial, the rest of the trial, which was another week, until closing argument came on a Friday. And then Thursday night, we had a conversation with defense counsel about a high-low agreement. And we went back and forth until we finally agreed on some numbers. And we ended up well, I don't know if you want me to tell you.
Yeah.
So the high low was 7 million for a low, and the high was 20 million.
Okay. So, and they also waived their right to appeal.
Correct.
Right to appeal. Correct. The case is over.
Okay. So you let the jury go. Is there something I don't want you to tell?
I want to bring up one thing that was kind of like just something that's completely extraneous, but it did enter in. Is we were trying this case right when the election was occurring too, and so there's a lot of unrest and there was a lot of things going on there. And one of our concerns was, because of that context, that we could have a hung jury. We didn't know what was going to happen with the election. We knew that there were people who definitely appeared to be on opposite sides of the fences, from what we could surmise. And we didn't know how that was going to manifest itself. And we were concerned with the hung jury. So that was the other thing that the high-low addressed, was that the low would kick in if there was a hung jury, which was a big concern.
Right. And that so was, you talk about saboteur. The saboteur came out the morning. I mean, I didn't stay out for the election. I go to bed early, so I woke up early, and I'm like, what? And
Yeah.
and when that happened, it was like a kick in the gut because I did not see that happening. I mean,
Yep.
I
I don't
thought
think
it
a
was
lot
a
of people did.
possibility, but if you looked at all the polls and everything, but when I saw that happened, I'm like, what is going on? And and it actually, Shauna and I, that was the one day that our saboteur came out and said, do we know our jury? Do we have any idea what they're going to do on this case? And we didn't.
I
And
can see why.
yeah. And so
Yeah.
we just kept trusting like that we put in the
The
work.
process.
Yeah, that we put in the work, and we just said, we're going to see this through, and we did.
So you agreed to a high low of 7 and 20.
Correct.
You released the jury. How long did they deliberate?
They deliberated on a Friday for an
Hour 45.
hour 45 minutes,
No lunch.
no lunch.
Wait,
And
that was it? An hour and
Yeah.
45 minutes?
Yep.
yeah,
So what are you thinking when you're getting called back that soon?
I was okay with it. It was a
Actually,
Friday afternoon.
we were pretty good with it. How many Post-its did we have when we're like invested, but
Detached.
detached. We had
Detached.
Post-its all the time.
I
So we
love it.
felt pretty good, and more relaxed than we ever had too. And so yeah.
So the thing that was concerning again was the jury. We couldn't figure out anything from the jury. Honestly, we spent so much time on forming the group. You yelled at me one time when I addressed the mock jury as, it sounds like this group believes this and that. And
Yeah.
you don't have a group. And like,
Yeah.
it's been
Yeah.
3 minutes, you do not have a group. So our
Yeah.
jury selection took literally 20 minutes, and we did the H2H voir dire, and we never really got going because the judge cut us off. The defense attorneys didn't know what to do, so they just started objecting without really having a basis other than, we don't like the
That's
question.
what's happening.
Yeah.
Yeah, we don't, this is too effective, Your Honor.
And the
Yeah.
jury came back, and the jury, they were giving us the answers, and they said, well, you're putting words in their mouth. I said, I'm asking the questions. I have not suggested a single response by anyone.
That's right.
And
Yeah.
so, but the judge said, no, that you can't do that. So they cut Shauna off, actually, of all people. I was able to get a lot of my questions out, but Shauna was handling the liability and damages part. And so she was cut off at the knees, like right when she stood up, and she was able to go with it and still get enough out from the jury, I think, at that point. But we couldn't read them. We couldn't read them. The defense attorneys had a jury consultant there with his computer entering all kinds of notes. We had no one. We had our team, just me, Shauna, Mike.
Well, that's a bunch of bullshit anyway. Oh, they are crossing their legs. That means whatever.
Yeah.
Okay, so they come back and
Yep.
voir dire, you did great. And then the judge cut it off. We don't know if we have a group. We've got a high low of 720. They come back and they give you
20.
20.
Yay.
We hit it on the head.
$20 million.
on
What
the
was that
head.
like when they said that number?
It
was perfect.
Yes.
It was the perfect number.
It was.
It
was.
And our client, it was perfect, and for him, it was the perfect number, and it was awesome.
And we had offered the night before to settle, instead of doing the high low. It said just pay 15 on it.
Yep.
And
Buy
then
it
we'll
out
do
for
it
15.
For 15. And they said no,
Nope.
they're not interested. And so when the verdict came back, they gave $5 million for loss of normal life, $10 million for pain and suffering, and $5 for the life care plan. And when the first one came in at 5, I'm like, oh, we're gonna get 15, and which would have been okay. I mean, but
you always want to beat the offer, though.
Yeah. So I mean, we tried our butt off. We still wanted to win, and we wanted to get a high verdict. So, and just so you know, the question about the how much we asked, like the focus groups that we did, the big data told us to ask for 77 million, and that was our number. And so when we asked for that in opening, again, Shauna asked for that in opening, it was a little scary in closing because our client looked so good and spoke much better than he'd ever spoken with us. And we'd met him like at his home before for prepping and everything, but he had a really good day. I mean, and the jury didn't see the struggles that he had going from the car to the court to the actual courtroom. And so so it was a lot. and then to ask the jury for that much, but we stuck to our guns. We stuck to our
I
guns.
love it. I
So,
love
and
it.
it
And is
wasn't
your
a failure.
client happy?
Yeah.
Oh my gosh. Yeah.
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 He is. It is absolutely life-changing money for him. He was been a believer. I mean, this has taken 5 years, for him to
Yeah.
get his day in court, and they promised to settle this case literally within the first year, first 6 months. They were going to make an offer, and so our credibility is on the line because I've told them that. Well, we're expecting an offer. We should have an offer at this point in time, and then that comes and goes. Then, oh, maybe after your deposition, and they liked our client, and no offer. And then after the experts, same thing, no offer. And so he had unbelievable patience,
Yeah.
and he stuck with us.
And I want to bring up one point that to me was really important. So our client's wife did not want to pursue a loss of consortium claim. She never did. And she'd always been a more reluctant participant. But I thought this was kind of good too. We split it up. So Nick put on, Bob, and then I put on Bonnie, his wife. So that's how we did it. And she was really nervous, but I told her, just like we had talked about, I said, look, we're just going to have a conversation. It's going to be you and I. And yes, there's these people here, but we're just going to talk about Bob, and we're going to talk about that, and it's just going to be like that, and just breathe and all this. And I just have to share that afterwards, I didn't even see this, but she did a fantastic job, by the way. She was very likable and very engaging. But afterwards, she went back, and our nurse manager who was there told us that she just cried. It was just such a cathartic moment for her.
That's
And it
what
was
trial
just
is for so
awesome.
many people.
Yeah.
Yes. She
Yeah.
was heard. I love that. We're running out of time, so let me ask you both. I'm going to give you an opportunity. I'm also going to give Jody an opportunity to weigh in here too. But what, just based on this experience you had, and congratulations again, what would you say to another trial attorney? Like, what is your best advice after having gone through this, and what you've learned and how you did things differently? What would you say to other attorneys?
What I would say is be open to other methods and other ways of doing things. And there isn't just one way. Like I said, for me, I never thought I used flip charts. Now I think I will use them forever. But just different ideas, and that's one of the things that Shauna and I always thought, like with this case, because it was so overwhelming, and you and Jody brought so much clarity to honestly, I keep going back. I know I said it already, but I thought the case was won in opening because it was so effective and just so coherent that the jury, and we kept going back to it with witnesses. Okay, here's what you're supposed to do when a patient's in distress, A, B, or C. And we kept going back to that same flip chart. In closing, we used the same flip chart we used in opening.
Yep.
The defense was all over the place. Meanwhile, we're showing, this is what we told you in opening, and this is what we showed you, and here it is again. And we brought the flip charts out again just to show them. So
it
I'd say
becomes
just
this touchstone. It's so
yeah.
beautiful.
So just
I
be willing
love
to
this.
try different things and different just methods, and get your head straight. And no trial is going to be perfect. And that for me, I'm pretty hard on myself, as I know you guys picked up on in Portland. But I just said it's not going to be perfect. It's okay. Just you're going to get the majority of it, and you're going to do fine.
Yep.
So
I love that. You went in and you had your own back. I
Yeah.
just
Yeah.
love that.
Yeah.
I just
And,
love that. Shauna, what about you?
My advice is the word that we started out with, and that is collaboration. So however you can get it, I think that's like just it's releasing. It's freeing. It's just, it's great to get, and in any form you can get it. Even if it's just by you doing it on your own, trying to listen to podcasts like your podcast, which is great, or talk to Jody or talk to other people, just collaboration is key. We feel like sometimes we're taking on the weight of the world by ourselves, with some of these cases, and the collaboration is just amazing to get a different viewpoint and just insights, and so that's what I'd say.
We're better together. We're better
Yep.
together. And
Agreed.
we have a whole group in H2H that can help those of you who are listening collaborate. That's so huge. Jody, closing thoughts from you, since you were so involved in this
She really
trial
was.
Wow.
and case. Yeah.
Yeah, I'll just say it again. It's just such an honor to have been brought into the circle, right? Because I know what it's like to work on a case and to be dedicated to it and have it be part of your life for 3 or 4 years. You had lived with this case for so long, and I'm sure it's not easy to bring an outsider into the fold. And so I'm sort of appreciative and humbled by the fact that you let me come in and tinker with it all. We've talked about a lot of themes: clarity and collaboration and curiosity and open-mindedness. I think I would add the word creativity. So
Mm.
at the end of the day, you know, there's an idea, we carry around this idea of what trial should be or should look like, or what we've done before. And I think that when you do collaborate and are open to a different way of doing things, it really opened the opportunity for us to get really creative about how are we going to tell this story and to have some fun. I know it wasn't fun those first couple of days. We were slogging through a lot of information, but part of our goal and one of the values in H2H is play. And so we were also trying to find a way to have fun and to release some of the tension that you were talking about,
Mhm.
Shauna, about feeling like you're carrying the weight of the world on your shoulders in this case, or Nick, the tension of feeling like you have to be perfect, whatever perfect
Mhm.
might look like, you know? So we injected some creativity and some fun in order to bring the case to life as well. I just thoroughly enjoyed working with you both. I can't wait to pick the next case to
I
work
know,
on.
likewise.
Yes.
Yeah.
It
Well,
was, it's a
congrats
huge one.
again. I'm so glad that H2H was here and able to assist. You guys did the hard work. You carried this, but as we always say, and we told you this many times, and I'm sure Jody said this to you, is we always, no matter who we're working with, you always say you are the expert in your case. We are here to tinker, as Jody said, or get creative or curious, but we want to, and that's how I think we're different, is we want to empower you to feel that you have the right story and that we've assisted, but that you really have owned it. And it sounded like that was exactly what you were able to do.
It's true.
So
Absolutely.
congratulations to you and to
Thank
your
you.
client. We're so excited for you. Thank you so much for being here.
Thanks for having
Great.
us.
Thank you.
Have you ever wished that you knew what the jury was thinking? Well, grab a pen and paper, because I'm about to give you instant access to a free training I created for plaintiff trial attorneys called 3 Powerful Strategies to Help You Read a Juror's Mind. It's going to help you to understand what the jury is thinking so you'll feel confident to trust them and yourself in the courtroom. Ready for the address? Go to sariswears.com/jury. Enjoy!